Welcome back to Court TV Live. I'm Michael Ayala. We'll get you back to court in just a moment. But first, we have an update in these other cases that Court TV is tracking. In Massachusetts, the jury returned a guilty verdict in the Irish firefighter rape retrial of Terrence Crosby. Crosby faces 20 years in prison when he is sentenced on October 30th. In New Hampshire, the defendant in the Amber Alert murder trial took the stand in his own defense. Dustin Duran claims that he killed the mother of his children to protect them from her. He'll be on the stand again on Monday. And in Florida, the jury in the Julio Fulio trial heard more testimony about the crime scene that allegedly links the defendants to the killing. Also, outside the presence of the jury, the defense attorney questioned some of the testimony about text messages involving the defendant. We're going to explore that a little bit in the show as well. All right. Right now, though, we want to turn back to Georgia for a motions hearing that's going on in the Cannibal killer murder case. Caitlin Goebel, is charged with malice and felony murder in the 2016 death of 19-year-old Morgan Bauer. Now, Bauer disappeared 2 weeks after she moved to the Atlanta area from South Dakota and was last seen near a park in Porterdale before she disappeared. Now, the defendant's boyfriend at the time, Jonathan Warren, was also charged in the case, and he has pleaded guilty. He is spending the rest of his life in prison. Prosecutors claim that the couple killed Bauer and then dismembered and burned her remains. The state wants social media evidence showing Goebel discussing her fascination with serial killers and the occult admitted into the trial. The defense attorney claims that those videos are far too prejudicial. Let's go back in now and listen to the defense's argument to the judge.
Thank you, Your Honor, for hearing this out. As the state mentioned, this is a blanket objection to everything that the state's trying to admit. Just to go over a couple of things, Your Honor, on the face of the motion that the state filed, essentially, Your Honor, they're saying that the reason for bringing in all of this evidence would be for motive. Your Honor, we're arguing, of course, essentially it's a backdoor 404 argument. Therefore, we're arguing against, Your Honor, because it's highly prejudicial. There's nothing probative against it. And because it's 404, then we would ask the court to do the 403 balancing test. And I don't believe that it'll pass because it's highly prejudicial, Your Honor. What the state is arguing that it's admissible. Generally, the conformity of the argument is inadmissible. Of course, they're alleging that it's evidence of motive, but, Your Honor, basically, it's showing propensity. What it's showing is that because of what my client did while doing cosplay or on her social media, her personal time, because she acted in this way, therefore she acted in this way in a murder. And that's one way the law says that it's inadmissible. We have a case law, Your Honor. Basically, let me give you that case in citation. 318 Georgia 579. That's a Georgia Supreme Court. That's Jennings v. State. Essentially what the defense gets from that, Your Honor, and I'll read, extrinsic evidence is defined as evidence that pertains to an uncharged offense arising from the same transaction or series of transactions as the charged offense. 2, is necessary to complete the story of the crime, or 3, is intertwined with the evidence regarding the charged offense. Your Honor, we're arguing that none of this is intrinsic, that it's not relevant. If you look at the videos that the state just played, this is all from TikTok. Now, I'm not big on TikTok, but the audio comes from artists, their songs, their music. It's cosplay, which is very common, and even I would argue some of the
Define that for me, please.
Sorry, Your Honor?
Define that for me.
So cosplay, Your Honor, is essentially where people dress up. They have, it's pre-made videos or audios, and then someone takes, so let's say I'm into working out. So let's say I go and I dress up, or if I'm into anime, or what's the action movie? Dragon Ball Z or something of that nature. There's a voiceover that someone already pre-made, and I dress up as a character and just play out what's being said, essentially. That's what cosplay is, Your Honor. It's not my client that made up these things. She's just dressing up to a video that's pre-made, and some other people who are more experienced in it have better videos. But that's essentially all it is. So that's the argument, Your Honor, that it's cosplay. It's very common, and a lot of these things were done around Halloween, which Halloween people dress up. They aim to serial killers or half of America is into crime shows or things of that nature. And also, Your Honor, if I can quote another case that we would like to present to Your Honor, it's 919 Supreme Court, it's SE 2D 595. It's a Supreme Court, and I believe the state also mentioned this case. It's the Rose v. State. And what we get from that, Your Honor, yes, in that case they allowed the evidence in, but what we want to focus on for the defense is in that Facebook post, Rhodes declared Lucifer is the reason, understands why I kill. And the reason the court allowed that to come in is because what they stated is Rhodes' statements to May's murder, which Rose complains on appeal, was given the time of the post. If you look at these posts that the state put for all the posts that happened, allegedly this crime was committed in 2016. A lot of these posts, Your Honor, are 5 years later. 2000, 2001, I believe there's some from 2019. So we'll argue, Your Honor, it's not relevant, that of course it's not intrinsic, and this is so far apart that the state cannot show that it's irrelevant in any way to the crime that was committed. In Rhodes, these things, the things that were posted were maybe the same day, maybe after. A lot of these things that the state's trying to just admit were 5 years after, and there's no connection to that. So basically, Your Honor, we object to everything that's being put in or argued on behalf of the state. One, propensity, that it's highly prejudicial. I would even argue that it would confuse the jury, because if they see something that happened years after the alleged crime, that, as I stated, propensity, because my client dressed up, she acted in this nature, because of Halloween or because of cosplay, then yes, she committed this crime. And also, Your Honor, the state argues ritual, and in this case, there's an allegation that the body was dismembered, the head was dismembered, but there's nothing to show satanic rituals. There's no markings, there's no, normally when it comes to rituals, there's markings, there's symbols. None of that was done to this body, and nothing was done pertaining to this case. All we have is the allegations or the testimony, possible testimony of the co-defendant in this case. And if that's the case, put them on the stand, we'll have the opportunity to cross them. But I think everything else is cumulative, that it's not intrinsic, that it's not relative, and that it's highly prejudicial, and it doesn't have a probative value. Thank you for hearing this out, Your Honor.
I take it there's no issue that she's the one depicted in the videos?
I'm sorry, Your Honor?
Is there an issue that she is the person depicted in the videos?
No, Your Honor, because as you stated, that's cosplay, Your Honor, and so it has nothing to do with this case, especially the time frame of when it happened. This is something she does on her personal time, and as I said, it's already, they're pre-made videos. So many people make these type of videos. It's very common. I don't do it, but it's very common. So that shouldn't be used against her, because it has to have a reason. It's not relevant. It's not probative. So we just ask that it be excluded.
Do you have any argument in response to the state's argument that the evidence that the state seeks to introduce goes to rebut her claim in her statement that she was under the influence of Mr. Warren?
I'm sorry, say that again, Your Honor?
As I understand, part of the state's argument, it is that the evidence goes to rebut her claim in her statement that she was operating under the influence of Mr. Warren, her co-defendant, and that this evidence goes to rebut that.
Do you want to say, Your Honor? Yes, Your Honor. So essentially what they're trying to show, there's nothing in these videos or in these postings that will show that she wasn't under the control of this co-defendant. There's nothing that helps the state show that she wasn't under the control. And like I stated, if he can testify to that, whether he was or not. But there's nothing by showing the cosplay. How does that video of her listening to music or repeating something that was already pre-made from an artist or anything show that she wasn't under control by this individual at the time of this alleged crime?
Could a jury find that the social media posts and videos together show that she may enjoy this type of thing?
They may find that she may enjoy cosplay, but we also say that it's irrelevant, so why put it in? And it's highly prejudicial, because what we're arguing is that because they see that she's into cosplay or she's into makeup and, you know, Halloween and all this other stuff, that what the state's going to argue is because of that, or what we're saying the state's arguing is because of that, therefore she committed this crime.
Well, my question was, could a jury find that the social media posts and the videos combined show that she enjoys that? So, for instance, the social media posts say that, or that she's in a conversation with Alexander Warren that says this is Bob kills people for fun. That post, that was on the same day as the alleged murder.
Your Honor, yes, Your Honor, but that's not a crime. And what we're arguing is propensity, because that's essentially what it is. If she did something here or she likes something here, then therefore she committed this crime. So because she likes things of dark nature according to these videos, then therefore she committed this. And that's what we're arguing against, and that's what 404 is against.
So, as I understand your argument, the videos are much later in time, and they're too late in time to be relevant to the murder that occurred, or the alleged murder that occurred in 2016.
That's when we're arguing objection.
How far do you have to go? How far would you suggest is too far? What about the day of, or the night of the alleged murder?
I mean, that's what Rhodes allows, Your Honor. In that time, it's because it was close in time. But they didn't say how far out, but in that, I believe in the Rhodes case that it happened, or the posting was the day after. But even with that in our case, Your Honor, of course, we're arguing against the ones that are further out, years out, for relevance and other arguments, but we're also arguing the balancing test as well.
So, what about the December 1st, 2016 meme that she posted, or allegedly posted, about serial killer documentaries? On the TV, and the photo says, "Kidnapped girl found slain, dismembered, hid in sewer." Any objection to that?
Of course, Your Honor, we object to everything. And like I said, Your Honor, it's the same argument. Although that's closer in time to what the state's asking, we still believe it should go through the balancing test. And we've argued that that's highly prejudicial. Now, for the time frame, like I said, just based off the Rhodes case, that the court hasn't defined what's a good time frame, what's not. And we hear the state's argument of closer in time, but we also feel that it should go through the balancing test as well.
Judge, what was your Rhodes citation again? I have 919 SC 2nd 595.
Your Honor, can I approach? I can just have a copy for you.
Yeah, I think we cite Rhodes as well, Judge.
Okay.
It's a 2025 case, I think.
And I'll also circle or have it in the this is the case here.
Thank you.
Thank you.
All right, anything else from the defense?
No, Your Honor, thank you for your time.
All right, so the judge posting some interesting questions for this defense. There was a series of videos beginning in about 2016, around the time of the murder, all the way up to about 4 to 5 years later. Which one of those, if any, can be admitted? Important question for the court. Let's take a break right now. When we return, the state is actually going to have their rebuttal argument against the defense's argument, and then we're going to hear from the judge. So we'll be there on Court TV Live.
I've committed so many horrific acts over and over and over.
Do you think you deserve to die for murdering those innocent people?
You tell me. I wish more than anything, David, that I would have done something other than the things I've done in my life.
Are you really a changed man, or is this some kind of stunt.
Interview with a Killer. 2-hour season premiere. Saturday night at 8 Eastern and Pacific. Only on Court TV.
Welcome back. We are wrapping up the motions hearing in the Cannibal killer murder case going on in Georgia. The state is now providing its rebuttal argument.
Ms. Daly, anything in rebuttal?
Yes, Judge, a little bit in rebuttal. One, in terms of this timeline we're talking about, the Facebook post being made in 2016, and then TikTok post not being made until 5 years later in 2021, well, it didn't exist until later. And it's nonetheless, so it's not as if she just didn't think about doing, you know what I mean? It just, the temporal issue there, I think, should go more towards weight rather than admissibility, because TikTok wasn't around in 2016 for her to post on anyways.
When did TikTok come into existence?
Okay, so 2018, but it gained popularity in 2020, I think around COVID time frames when I remember at least TikTok becoming popular. And she started posting in 2020 or 2021. I'm not sure when the first post was. But they aren't all around, in 2020 she started posting TikTok videos. They are not all around Halloween. They are regular every month of the year as well. And importantly, they're very close in time to her statement that she makes, I think, which was in 2023. I'd have to look up the exact date of the time when she goes in Peoria, Illinois, but I think it's July of 2023. So she's been posting TikTok videos in only for 2.5 years or so, at the point in time in which she's making her statement, which is drastically different from obviously her presentation on these videos. I also think it's important to note, if we're talking about this being cosplay and cosplay situation, but that's just cosplay, it has no bearing on anything. It's kind of analogous to sort of the rap lyrics argument that's made at times, where if you are going to rap or sing a song about a particular murder, right, and the facts that are relevant to that murder in particular, then later you can't say, well, that's just my artistic expression. Like, that is still evidence to show that. A jury, you can make that argument to a jury, but that's still information that's relevant to show motive regardless. And then I think that covers what I needed to say in rebuttal, Judge. I'll end with this. Our motion references motive, but I want to be clear. There's some of the evidence that would only go to show motive because it isn't intrinsic based on the time that it was made, or isn't intrinsic based on sort of refuting her statement or the specific facts that occurred in the murder. But there is a lot of this that is not just present for motive, but it is inherently intrinsic to the murder in the facts of that murder itself.
So, you've given me pages of statements, posts that she's made. Are you seeking to introduce everything on all 14 pages?
I mean, practically, I'm sure we will not, Judge. And I'll note this, it's not really 14 pages. I think the first 3 pages have content on them that was actually posted and discussed, and then some of it is sort of where the writing runs off to another page. And then pages 8, 9, 10, and 11 have content on them as well. So it's not just 14 pages. That's why I went through and highlighted a lot of them, because those, I think, are the ones. I think there was one more that I forgot to highlight on page 1 where she uses audio talking about killing one person. It's towards the bottom of the page. Other than that, no, I mean, those are the ones I found most relevant. I hate to limit myself at this point in the game, so I would say yes, with an understanding that we are very careful in what we will present. I don't think I'm going to need to present every single social media, message that's ever been made by her, but there are some that will need to be presented.
The dates that are reflected on the dates of posting?
Yes.
If you will repeat You said that you had divided them into 3 categories, 1, 2, and 3. If you will, repeat the description of these categories for me.
Yes, sir. Category 1 is the sort of innately and obviously intrinsic evidence because it's either made at or around the time of the murder, or it is so specific as to the facts and circumstances of this murder, some of the cannibalism, the severed head ideas, or it is made contemporaneously close in time. And then category 2 is ones that would show a contrast or disprove her assertions in her interview that she was made to participate in this, that she's just meek and mild and it wasn't her idea and she didn't really have anything to do with it. And that category would simultaneously corroborate Mr. Warren's statement, which is the opposite of that, and I have to do that. And then the third category is this occult serial killer murder idolation idea that would strictly go to show motive. That's the satanic worship idea. And a lot of them, frank, they overlap because sometimes she's discussing Satanism, the same vein that she's talking to Mr. Warren or something. So.
Right. Anything else for anybody?
No, Your Honor.
No.
I'll take the matter under advisement, Mr. Rule.
Thank you for your time, Your Honor.
Thank you. Thanks, sir.
All right, so the judge took those arguments under advisement and said he will make a ruling at a later date, and of course we'll update you as soon as he does. Let's bring in our guest for this hour. Joining me to discuss is National Trial Attorney Michael Jaffer. Michael, great to see you. Thank you so much for joining me on the program. Now, this is an interesting situation. I think it's clear. As you heard, 14 pages of content on social media, including videos, very disturbing videos that I think, if they're presented to a jury, could cause problems. They range from 2016 to about 2021 or so. Apparently, the one that was put out in 2016 actually talks about cannibalism, which we know is an issue in this case, also talks about beheading, which is an issue in this case. So the state is claiming it's intrinsic. Once you make that argument, you don't even have to get to the prejudicial part because it's intrinsic to the case, because it sort of mirrors the facts in the case. So let's start right there with the videos from 2016 where she's talking about cannibalism, and beheading. What do you think the judge might do under those circumstances?
That's going to be a tough one. The decision that the judge is going to make, this is why we have the system that we have. The judge knows that by allowing this evidence in, this woman's pretty much convicted. This is going to be the toughest decision. What do I think the judge is going to do? This is a tough one. This is a coin flippy type of decision, but I think the judge is going to let it in. As a defense attorney, I just don't think it should be let in because that's the end of the case before the case even starts.
All right, so now we got these other videos going from like after 2016, going all the way to 2021. I think the argument that it's intrinsic, and I don't think the state is even making that argument. You can't make that argument. But they're saying it's probative. We want to bring it in. The defense is saying too prejudicial. We're looking at one of those videos made in about 2020 or 2021. What say you on that? The idea that, again, I think these are so prejudicial that I think the probative value is far outweighed by the prejudicial effect on a jury. So what do you think the judge might do with these videos that came after the murder in 2016?
If I was a judge, I would be looking to see whether or not the defense attorney admitted evidence that she has changed her views between the time that those videos were shot and the time that the murder happened. I don't think that was introduced. That would make the judge's decision more difficult. I think the judge was looking for anything that says this was in the past, this was behind her, she's changed her life. Because then at that point, they would not be probative at all because this was a prior life that this woman had and prior views. That didn't happen. So I think, again, I feel like the judge is going to let it in, but I just don't think it should be let in.
Yeah, I agree. One of his questions concerned me. If I was a defense attorney, it would concern me. And he says she's also claiming, right? So the guy who, her boyfriend, is claiming that she told him or asked him to do the killing, and it was really her idea. She's claiming she was under his influence, and that's going to be part of her defense. So the judge is asking, look, does it rebut that claim? Are they allowed to bring it in to rebut this idea that this wasn't my idea, I was under his influence, but yet here I am posting these kinds of videos? I think the state has a decent argument there in that case.
The state has more than like a very decent argument, and that's why I think the judge is going to let this in. For me, just the sanctity of the system is when a trial is over before it even starts. What if this woman didn't do this? What about the chances that she didn't do it? You know, she loses that. It's basically she's collaterally stopped in the minds of the jury from saying that this is not who I am because all this stuff was admitted. So they have a great argument. It's just, man, the case is over the minute the judge lets that in.
Yeah, I can't agree more. So I think, Mike, if you're representing her and the judge lets this type of evidence in, I mean, this is part of the job of the defense attorney. You got to try to get it out. But if he lets it in, do you then start talking to the state about a possible plea, maybe trying to get it to some date for her to possibly be paroled?
That's exactly what I would be doing. I did the analogy yesterday. The amount of time between now and the JFK assassination, that's the amount of time that has lapsed between now and then. That's how much time she would be facing in prison if she were convicted on these charges. It's an eternity. So if I was a defense attorney and this is the case, I'd be arguing the case right now. This is where I win or lose the case is right here. I don't even win by winning. I just don't lose by winning.
Yeah, I would agree. All right, Mike, stand by.